so we're excited today to have Chris Voss of Voss Law with us. Chris is a presenting sponsor for the group. So first and foremost, thank you to Chris and his team for being huge supporters of the above asking community. We don't function as a community if we don't have people who believe in what we're doing. So Chris and his team are certainly, one of those strong advocates or ambassadors for the group. So we're thankful there. But Chris is, we've had a few conversations with him. I was just telling him before the call, Keely had a few conversations leading up to this SME call today with Chris, and every single time she's blown away. She's like, man, that guy is really, really sharp. So I'm excited to get some FaceTime for the community with Chris Voss. So Voss Law has been in existence, I think, almost 20 years you've been practicing, Chris. Is that right?
Yeah, man.
Close to it. You still look great, though.
Great.
So I'll throw that out there. So if I know we've said this at a few of the on-sites, but Boss Law is Keely and I's personal title services company. And we look at them as more of a partner than just a title company. But we use them for a few reasons. One, because they're focused on the REI space, right? And I think that's so important for our wholesalers, developers, flippers in the group, realtors. They are really focused on our niche, which is so important because it's those few areas that you typically wouldn't capture that get you into trouble. But when you're working with somebody who's really focused on serving your type of business, it's everything. Also, Chris and his team, they run the Sunshine Investors Fund. Before I give away too much of Chris's biography, I'll let him introduce himself, talk a little bit about his business, and then we will jump into joint ventures and private lending for the REI community. So, Chris, tell us a little bit about yourself.
Well, Mark and Keely, thank you so much, and Amber, thank you as well. And we I guess we can move the danger of giving me control of the slides here. Did that move? There we
Yeah,
go.
there you go. Perfect.
So so we're a little bit of a different model, and thank you guys for being such great clients. We're effectively a title insurance company dressed in a law firm's clothing. So our model is basically we're priced like a title company. We can just do a lot more than a title company is allowed to do because we're a law firm, and we don't really practice the billable hour like a traditional law firm. Our attorneys are here to help, so you're not going to see, unless we're drafting a note or mortgage or some particular product. Our job as lawyers, and Andrea, our managing partner, and Alyssa, all of our attorneys, our job is to try to help get the deals done, however it might be. And it's to do that without hitting you with these big bills. So, we don't send out billables. We don't put attorney's fees on line items for jumping in and trying to save deals. That's our value add. That's if we're helping you guys, it's helping us too. So that's sort of our approach. But at the end of the day, we're kind of just a juiced up title company. And we can help with about anything you could come across. And our consultations are always free. We really want you to have access to our attorneys and our team. So today is, there's Mark, you and I were talking about just like there's just a million ways that these joint ventures can go in structure and concept. So I'll try to touch on just the high level ideas. What I'd say is if anybody's out there that wants to talk about details of their particular deal, or one thing, Mark, we were talking about is like for a LLC, right? We'll give you what we think is a really good operating agreement for free, and talk you through it. And so if anybody out there has specific questions or is trying to structure a deal, we're happy to spitball that with you. Just call the office, and we work like a doctor's office. So just book a time that works for you, and one of us will be there. So we'll touch today on the JV sort of framework, the most common structures, the structures that we think work better. Um, structuring, is there private lending in it, which Mark, you had a great example of in our first call. And then how does it work with title insurance and the deed? What are all the different ways that that shows up in the actual transaction itself? And then, we always talk about JVs when they're great, right? And when they're great, no one talks about even the structure because it just worked. But man, when they go bad, it's like just think divorce and divorce litigation, and they get hot. So we'll talk about how to try to avoid when try to avoid going south and things going bad to start with, but some things to think about in the event that it does go south. Um, so just jumping straight in, how do you structure these deals? Well, I think the best way to address that is where is the money coming from, right? Is it lending or is it being invested into the, are they becoming a part owner? So, and Mark, if you don't mind using your Catalyst example, um, I thought that was a great way to describe the different roles.
Yeah, yeah, I can touch on that real quick. So, typically when we think about structuring joint venture partnerships, we're normally bringing a capital partner in to either provide gap funding or to provide the entire funding for the deal. So that would be total acquisition costs of the land or total acquisition costs of the existing property and any renovations or the build costs, right? So when we think of the catalyst in that scenario, the catalyst is the operator or the person that is typically finding the deal. They're coordinating the construction, right? They've underwritten the deal to understand the various exit strategies and valuations. It's really the person that is driving the bus on a real estate investment transaction. We call them the catalyst to the transaction. And then the capital partner, we call that the joint venture financier. So it's the person providing the financing. And to Chris's point earlier, it could be different in every scenario. Sometimes the financier is providing all of the financing. Sometimes they're only providing a portion, 50, 80% of the financing. Or you can even get more creative where they provide the initial funding to get you into the deal. And then the catalyst is providing the remaining funding, like working capital, or if the project goes over budget. So there are a million ways to structure a joint venture agreement. But I think the core tenets are you usually have the catalyst, the person that's driving the bus on the deal, and then you have the financier or joint venture financier, the person that's providing some type of capital or funding for the deal.
All right, that way better than I could have said it. Uh, so you just use those players, right? So you've got a lender, you've got your JV investor, and then you've got your catalyst. We represent a lot of lenders too. And a lot of times when you're watching a money guy or go from lending to becoming an investor, an owner, often it's because they can get a better return, right? So in Florida, if you're a lender, you're capped by usury laws. And if you're a Florida lender, that means you're capped to 18% per annum plus points. So sometimes you'll watch a lender convert from lending to investing because it's going to give them a better return. They look at themselves still really as a lender, but now they're an equity owner. With LLCs, the owners are called members. And so now they're a fellow member. And if you just said if we left it a very simple deal and you're going to buy this particular property and you're going to do it as individuals investing into an LLC, right? So you're going to go, we would almost always, some people will say, well, what about a land trust or what about whatever? But usually an LLC is just a really simple, clean way to acquire the property and structure the relationship between the catalyst and the JV investor, the funding capital. And so you create an LLC, you fund it, and the LLC closes on the property. So who owns the property? The LLC owns the property. Who owns the LLC is the catalyst and the investor. And that is by far the most common structure of all things JV. You can get a little bit more complicated. You can have twists on it and we'll talk about actual different forms of ownership on title in a minute. But the most common way is to go ahead and create a new LLC, fund it, buy it, which then brings you to the rules of the game. And Mark, what we were talking about for today was probably focusing more on what benefits the catalyst versus necessarily what benefits the investor. And so, oh, sorry about that.
Karen, I just want to offer one other thought for the group, and also say that you can touch on this in your talk track. So what you framed up is, hey, we start this LLC, and then in the LLC and the operating agreement for the LLC, we determine the splits for the person that's bringing the money and the person that's running the transaction, right? The catalyst running the transaction and the financier, capital partner. So that's one way, one LLC, both parties under the LLC, typically as individuals. But what we also see commonly is that you'll have two LLCs going into a joint venture partnership. So I just want to throw that out there to the group, because I know there's a couple folks on the line that have, maybe 10 active deals right now that they're structuring it that way, where, that capital partner has formed an LLC and they're the JV financier, and then the operator also has their LLC that they run their business out of, and then they're the catalyst. So that's another spin, if you will. You said, hey, there's a lot of flavors. That's another common flavor. I think those are the two most common. One LLC for both parties, and then two LLCs going into agreement together. So I just want to throw that out there.
That's a perfect clarification. And honestly, we probably see more of the example you just gave, where you have entities owning an entity. So you have LLCs owning an LLC, and we probably see that more often than individuals. But either way is fine. It brings up a great point to what matters the most is what the operating agreement says, right? So when you look to the law in Florida doesn't consider emails, verbal, just like when you're dealing with contracts, right? So, if someone asks for an extension in an email, does that mean that they got a contract extension? No. It has to become part of the contract. Well, similarly, the operating agreement is going to be the end all be all of how a court would look at your transaction. And think about the operating agreement telling a story, right? So if you're a good storyteller, you're not skipping any details. And the worst part that we see in operating agreements where people sort of self-helped it is that it left out what we call war games. So, a war game is like play out how this goes if it goes poorly, right? And then take that imaginary fact pattern where where the project just completely fell apart and people didn't do their roles. So play out these different scenarios and play it out against what your operating agreement actually says, right? And you can see that if you talk it out and you compare that against what your operating agreement says, because most of the time the operating agreements were too ambiguous, right? They didn't get into enough detail. So to your entities owning entities, the only real issue with that is that you're going to have a more complex operating agreement, because if anyone that's bought a property with a LLC knows that, like, as the title company, I need to see like who's authorized to sign on behalf of the LLC, right? And so similar in the operating agreement, it needs to go into more detail as to who's authorized for the LLC that owns the LLC to make decisions, if that makes sense. So the more complex you make the ownership, the more complex the operating agreement has to be. It's required, or it'll just be inadequate. And you had a great point. When the market's going like this, it's going vertical, and everything works great. Nobody ever talks about whether or not their operating agreement was adequate, because it just doesn't matter. And so just jumping into what are the points that for the catalyst that matter the most is, in an operating agreement, if I'm representing the catalyst, I want to see the catalyst have, if I can convince the investor to do it, like full autonomy, right? Very much like a lender, right? When you borrow money, the lender doesn't get to chime in and say, I want you to paint the house pink, not blue. So what kind of input into the transaction is the investor going to have? And, and in the perfect situation for the catalyst, the operating agreement gives, full authority to the catalyst to make decisions. A lot of times you watch people pick fights over, how good of a remodel it should be, right? Should it be better or should it be worse? Or the one that we often see is price point when it's time to sell, and disagreements over that. Well, if the catalyst has full authority and doesn't have to seek votes from the investor, then you're not getting into all that stuff. It is what it is, right? And so we would try to structure the operating agreement in the way that the catalyst is the managing member and the investor is just a member, right? And so the managing member gets all of that sort of carte blanche control. That is sometimes the case. You often see that that's great when you've got a really seasoned catalyst and a very loyal investor, and the investor is just happy time and time again with the return. Sometimes it's better than others, but over the relationship, there's just this trust from the investor that the catalyst is going to do it over and over. And that's where we get to get, really good language in the operating agreement in favor of the catalyst. Where it gets like a little more wonky and there's a lot more rules is where the investor wants a voice, right? And so now you have like co-managing members, and you have to have voting percentages. Like, well, a lot of times there's just two, right? There's two parties in the deal. And so the only way to do it, and if it's say a 50-50 split, so when you have this co-managing situation, what really matters is who owns what percentage, right? So if the catalyst is 60% and the investor's 40% ownership, what percentage are you going to pick to have a prevailing vote, right? To where you can make decisions. And that's where you could have provisions in the operating agreement, like, we're not going to sell the property until there's 100% vote, right? Until we both agree. And which is usually fine, except when it's not, right? And the problem with disagreements in operating agreements and operating partners is it locks the property up, right? Because even if the catalyst came to me and said, we're selling it, and I look at the operating agreement and I'd say, well, I need both signatures pursuant to the operating agreement. I need a resolution signed by both of you. And unless I have that resolution, we're not closing, right? And so that's where these disagreements come into play. And our best advice is to take an operating agreement like what we give to you and walk through it, walk through that language. And Mark, like we were talking about, and Keely, we were talking about before we went live, was most of the time when somebody comes to our office, they've talked through percentages and roles, how involved, how uninvolved, and so at that point for us, we're just advising on how to tweak the operating agreement. But, and those are kind of the higher points: percentage, voting rights, voice in the game. Another one that we bump into all the time is priority of payment, right? So who gets paid first? And where we see that is with like management fees. So the Catalyst is a percentage owner and taking a management fee for doing all the work, right? Well, how does that get paid out? And let's say that there was a certain threshold. Sometimes you'll see threshold amounts where the investor gets paid in full first, and then there's splits, right? And that's where you get into priority of payment, and those are huge. That's probably the biggest point next to control and voting is how do you get paid? What are the expectations? And you better damn well believe that operating agreement should accurately reflect it. And
we'll take a step back, Chris, and I don't want to touch on this because this is important. The idea of getting into more complex deals where there would be a management fee associated, right? That's a bigger, a bigger transaction than your typical run-of-the-mill single-family home where you're just doing a simple equity split for both parties. But you mentioned before, as a key point, I want to point out to the group and then also get your thoughts about the different types of transactions that we see. You said that we clearly need to spell out who has the voice in decision making in the operating agreement. So in the case that we are the catalyst and we have a financier coming in, we probably would be best to make sure that we have all of the say in how the project will unfold, the price point that we're selling, the type of renovation. You really want that JV financier to be somewhat of a silent partner. And I know that's easier said than done because these are typically people that are somewhat arm's length to us, friend, family member, coworker, somebody in our network. So we are involved with them. But you still want them to be somewhat of a silent partner providing capital to use the catalyst. That way it gives you the opportunity to pivot and make decisions as you see necessary, right? So that's point one.
yeah,
And then just to think about another scenario. So, in the event, let's say the group, we're partnering with each other, right? We're collaborating on a deal. We're both investors. We're both typically catalysts, but we came across a deal. We're going to pool capital together. Would you think it would be best practice to still have one of those parties as the primary decision maker for, let's call it voice? I think I forgot the term that you used, but kind of voice in the deal, right? So the decisions that happen, would you still advise that we choose one party to make those decisions so that you don't get into this, kind of stuck scenario in the middle of the transaction?
I mean, like, raise your hand if you like being Monday morning quarterbacked, right? And and that's kind of the more you share control, the more cooks you have in the kitchen. It's just like in life, it's just not as clean. And so it's not to say it's not good. It's just that the example we often use that relates to non-attorneys is think about like when you've read a power of attorney, right? And the power of attorney just says like under this power of attorney, you're allowed to do all of these things on behalf of this other human. Well, the operating agreement is going to be very similar where it defines the roles of the managing member, right? The key is it's just the manager, right? Sometimes it's the managing member, sometimes it's a manager, but it's the managing is somewhere in this actual definition of this person's role in the operating agreement. They're either the manager or the managing member. And it's important that it says, without the authority of the other members, the manager or managing member is allowed to do this, and sometimes it's just generic and it says all things necessary to improve and to finally sell this property. And the manager can, or the manager can, has the authority to sign anything, has the authority to withdraw money from bank accounts, and when you've got less authority, we call them handcuffs. And sometimes handcuffs are great, right? Like if you just infuse several $100,000 into a operating account on behalf of this for remodel, you'll have where this is just an example of almost a blend where you'll have withdrawals over X amount have to be approved by multiple members or something to that effect. And some of that's just designed to keep everybody honest. Because probably one of the most common things where things go bad is that somebody took money for something other than this project, right? And that's not uncommon. We see that, especially every once in a while, you'll watch somebody get upside down on one project and borrow from another, kind of Bernie Madoff style, hoping that this one gets better and then they'll return the money is always what they say. But so, you can have a bit of a blend, you can add some handcuffs, but the cleanest for the catalyst is always that almost carte blanche authority.
So I want to share a couple of like from the real estate agent perspective, a couple of like this is how this translates in real life, right? Messy operating agreements or lack of an operating agreement in real life. And I also want everybody to keep in mind that this is over the course of the market being in a really good place. And now the market's in not so great of a place. And so it becomes extremely important right now that you do have all of your I's dotted and your T's crossed, right? Because money, the threat of losing money, the worry over markets, right? That adds a whole nother emotional dynamic to partnerships. So some real life scenarios where we've had where I have seen people in messy operating agreements or partnerships not having operating agreements, right? I've seen properties get locked up in terms of the decision making on what's going to be spent in the renovation. So you've got multiple people and they all have different ideas about should we do the $3,000 appliance package or the $9,000 appliance package and what tiles should we put in? And that property is sitting and it's being eaten away by holding costs, right? The house comes out looking like a hodgepodge because nobody can agree on anything. And so they get less of a sales price when they go to sell it. They can't agree where to price the property. And somebody wants to price it really high and the property just sits and sits and sits and the listing goes stale. And again, they make less money. So, that's kind of that like too many cooks in the kitchen, the property gets locked up. I've seen a partnership where one person brought capital, the other person was the catalyst. The capital partner was not protected at all in the operating agreement. That person actually sold the properties, the lots, without the capital partner even knowing about it. And essentially there's nothing they can do about it because of the way that it was structured was very one-sided, right? Partnerships where and so the point here too is also like whether you're on the lending side of it or you're on the catalyst side of it, right? Making sure that whatever you're entering into, you're comfortable with, and that the person that you're partnering with, you trust, because there has to be an element of trust, right? And understanding what you're getting into. Also, like an operating agreement where one person was a lender and they thought that they were going to have some say in what was happening. As the thing started to unfold, the catalysts actually are terrible, don't know what they're doing, right? And now this capital partner has no say, and it's their money that's out on the line, not the catalyst. They've got no capital invested, right? So you really want to be like fleshing out all of these things to make sure that your interest is protected. But in terms of like the single kind of source of truth or the single decision maker, right, that catalyst should be somebody that understands real estate, understands investing, understands the market. And you guys have already kind of talked through not just the logistics of the partnership itself, but also kind of getting really aligned. I think right now it's very important to be really aligned on the strategy for the property itself, not just the partnership, right? Making sure that you guys are in agreement about what level of renovation you're going to do, what you think the dispo price is going to be, are you going to stage it? Are you not going to stage it? All of these different things to make sure that at the end, because what happens is those partnerships start to crumble. And then at the end, everybody loses out. Like you're not getting the best purchase price. You guys are like not doing the right things because one person wants to save money, or you're listing it with a really crappy realtor, or whatever it is, right? It's like at the end, it can really go south, even if the project has gone well the entire time. So I just want to say that, you want to make sure that you're really buttoned up on those things, because in real life they get ugly.
Yeah, and all of those are great examples of how it goes bad. I mean, the thing about like a partition case and or a foreclosure case versus an operating agreement case is that partition cases are straightforward, right? Like how the court deals with a partition case, very clean in terms of litigation. Same thing with a foreclosure, right? The loan was in default, they're allowed to foreclose, the foreclosure marches forward. What the problem with operating agreement litigation is that it's super sloppy. It's very expensive because the court is now left to figure out ambiguities, right? And and then you get into experts, right? So which are very expensive. So you're going to need an accountant to go through forensically where all the money went, and so not only is it just dysfunctional, but when they get litigated, which ultimately, if you can't come to an agreement, the only way to liquidate the property is to get a court to step in like a partition case. The problem is that it's not a partition case, it's a breach of contract case, right? Because somebody's arguing that somebody else breached the operating agreement, and they're awful to watch. I mean, we years ago stopped taking them as cases on the litigation side. We don't do any litigation today, but we used to do a lot because jokingly, how many people do you know leave a divorce case and they're like, I just love my lawyer. Every dollar I gave my divorce attorney is the best money I ever spent. Everybody leaves a divorce case angry at each other and angry at their lawyers, right? And that is exactly true for an operating agreement case. You're going to get frustrated with the system because it's slow, the judicial system, it's expensive, and nobody's happy. So we would lose clients even if we did a great job litigating the operating agreement because it's just a terrible process. And so it's not to say that even with a really well drafted operating agreement, you don't have the potential for ending up in litigation, but it'll be a lot cleaner because it gives the judge a path, right? It's when you didn't articulate all these different scenarios in the operating agreement that it gives the court a real challenge. And it just gets super sloppy, which in law and litigation equals expensive. And so you don't often, usually once people start seeing legal bills, they come together and figure out it's a lot cheaper to work together than it is to fight each other, which is probably the best part of the legal system for operating agreements. But using some of your examples, Keely, it's mainly the times that we see these things fall apart is where the expectations weren't very clearly defined, and then then when it comes time to closing, it leaves room for argument, right? And so that's one of the main ones where the catalyst felt like they should get more money because they worked so much harder than they thought, right? The investor, capital investor, thinks that they should be getting more money because the catalyst did a terrible job and ran over budget, and so that happens all the time, but the operating agreement can get around that and make it very clear. And what will happen is we'll say, well, let's still sell the house and we'll hold the money, and you guys fight over what the operating agreement actually says, right? The one of the best examples that you gave, Keely, is where the investor thought one thing and the operating agreement said something else, which is where that priority of payment is so important, right? So that's where like the investor might expect to get all of their money back first and foremost, and then you split profit, right? Whereas you could have that totally different, where if it's defined wrong, the project could make money, but in theory, the investment partner, if it was just split as a whole percentage, like 60-40, and it didn't prioritize the capital first, the capital investor could get a pretty bad deal there, and so those are the things where honestly you're sitting there with a word version of the operating agreement, and you're having the conversation, you're brainstorming, which that's the time. It's like your first date, right? It's exciting, everyone loves each other, this is, and then it becomes a bad marriage, right? Like, but it's in those excitement periods that you're literally walking those terms into the operating agreement, and you don't always need a lawyer to do that.
Let's touch on something, Chris. I think it's important to flesh it out for the group. So we talked about a few things. So profit splits commonly on the JVs are 50-50, 60-40. Those are pretty common when you're bringing in an equity capital partner. We talked about control. That's who has the voice and decision making for the project. We talked about management fees, which I think for most of us that really won't come into play where we have such a large and long transaction that us as the catalyst or operator that we're charging a management fee. Instead, what we would normally do if it's a comprehensive project is we would do the 60% of the split instead of the 50-50, right? We'd have a larger equity split for, let's call it sweat equity time in the project.
Where we see the
Please.
management fees, sorry, just so I grab it while you're
Please
saying
flesh it
it.
out. So we're here. Yep.
The management fees we almost always see when the catalyst is a GC.
Okay, fair. Fantastic. That's a great point. We have a few in the community too, so that's really helpful. So yeah,
Right.
I guess that's really fair. So for the group, for the good of the group, in that case, you may still do a 50-50 equity split, but then there's an additional fee, $40,000 paid each, over the course of 12 months or, whatever the transaction may have for the GC that's coordinating all of the construction management. So that's a fair point too. I think the capital
What is an
contribution.
example of what you typically see for kind of those, GC partnerships? Because we have had people ask about, how they would structure partnering with a GC. So what's kind of the common way that you see that set up?
It usually is dependent on the sweat equity part of it. And what I mean by that is like if the GC is not putting in a lot of capital, right? But one thing they're doing is they're going to run a good show, they know, and they're also going to be able to save money versus hiring it out, right? So sometimes you'll see what the agreement is that you'll have the operating agreement, and then we'll still structure like a construction agreement with the catalyst or the catalyst contracting company, and you'll either have like a pure cost, or if let's say that the going rate is cost plus 20% for a GC, and they'll say, well, we'll split it and I'll do it as cost plus 10, right? And that's some of the benefit that I'm bringing to the relationship. that's almost always where you see the management fees when it's just when the catalyst isn't necessarily a contractor. To both your points, it's usually just a clean like split getting into the priority of payment, right? Like, does the investor get their money back and then the split, or however you do it? So the management fee is usually someone who's licensed in some form or fashion.
Chris,
Capital
is it
contribution pieces. Go ahead, David. Go
well,
for it.
is it pretty, what do you see the most of? Like, what is the most common structure where I guess you have the investment components paid back so that people can pay off their lenders or pay off, whatever's been put into it. And then immediately off of that, you've got X amount of dollars left, and that's the profit. And that's now, if there's a management fee that gets paid out, and then there's a split, or it's the split. Like, what's the most common thing that you see and would, I guess, encourage people to incorporate into their operating agreement?
I'll give you kind of the answer in reverse, and
Okay.
it typically has to do with how sophisticated the lender is, right? So the
Okay.
lender is turned from a lender into an investor,
Uh-huh.
right? And so if I'm the lender, I'm thinking I could just lend you the money and I could get 12%, 15%, 18%, whatever you agree to. But in this particular case, but when I'm a lender, I'm getting my money back, right? So that's like even if I foreclose and so long there's equity in the property when I foreclose, I'm getting my money back. So if I have that mentality just flipping into an investor, I fully expect that I get my money back and
Mhm.
then we're splitting profit. And if I'm looking at it as an investor, I'm thinking, I'm going to do this. My risk is the operating agreement isn't clean. So if this thing falls apart, when I'm a lender, I just foreclose, and that's easy enough. I have a lot of safety in that. When I'm an investor, it's the Wild West now, right? And so my risk has gone way up in the event of this defaulting and falling apart. So I'm looking at it as the investor as I better be returning more than 18%. Otherwise, why would I do it? Right? Because I'm way safer just being a lender.
Mhm.
Unless I want to be in and want to be like half investor, half catalyst, or but if you're just looking at if we for ease of conversation, catalyst investor, investors uninvolved, the most common thing we see is the investor doesn't really want to be involved in your decision making process. They may put those handcuffs on so that they can have some oversight on the draws of the money, right? So think of it almost like a construction draw is
Mhm.
what those handcuffs would be like. And that's just to kind of keep you in check like a bank would. It's more like trust, but handcuff sometimes has the wrong connotation, but it's really more like trust but verify like a construction loan.
Checks and
So
Chris,
balances.
I want to offer some thoughts for David and for the group. So typically what we see is that the capital contribution is paid back first. Think of it as
correct.
first in, first out accounting, right? So it kind of sits on the transaction like a lien. I bought the house for 200,000. I put 100,000 in the renovation, but then the capital partner gave me 80,000, right? So all of those things have to be paid off first. That the renovation costs, the acquisition, and then the capital partner's contribution before the equity split comes into play. In the event of a management fee, that would probably also sit in the hierarchy right after the capital contribution, right? So the capital partner gets paid back his 100 grand, then that management fee, maybe that 40 grand, that's paid back first, and then the equity split. Maybe a little different in the case of a GC arrangement. That GC may say, hey, I want to get paid no matter what because I'm using my time, my guys, my team. So that may just be more of a charge, an additional build cost for that management fee. It's not really considered a management fee as much as it is a fee for the build cost, right? But I think the general idea is that the capital contribution gets paid back first. That's what most investors will feel comfortable with. So, Chris has given this example of, 12 to 18% on the return. But, if they're giving their capital up as an equity partner, they stand in the face of a 50 or 60% return normally, right? Maybe 40%. Still better than 12 to 18. So
Mhm.
where I think we really need to think about the math is what happens when things go wrong.
Mhm.
So if you think about it, if the property goes negative, well, it's going negative into that capital partner's contribution. So I think you have to spell out in the equity agreement, or I'm sorry, in the operating agreement. If we lose 50 grand on the property, my capital partner put up $100,000. Well, they lost 50% of their equity, and maybe the catalyst loses nothing, right? So that's something you have to spell out is that in the event of a loss, who absorbs the loss? That's important. Oftentimes what you'll also see in these JV agreements is that the capital partner comes in, they give 100 grand, but then the catalyst, they had to fund the working capital, and if they go over budget, they have to fund the over budget amount, right? So the financier gave 100 grand, and then that catalyst, they ended up spending 50 grand. So then in that case, what you probably want to do in the operating agreement is say, capital partner's contribution is 100 grand, the catalyst contribution is 50 grand. So then it's like, okay, 70% ish, 67% of the transaction was the financier's contribution. The other 30% was the catalyst. If we have a loss of, let's say, 100,000 for simplicity, that capital partner is absorbing 70% of that loss, where the catalyst is absorbing 30% of that loss, right? So, to Chris's point, the war games, I think you really have to have them spelled out. In the event of a loss, who absorbs the loss, right? So that's important. But I think what your question was, hey, who gets paid, right? What is that hierarchy? And it's normally that capital contribution is going to come out first.
Yeah,
We have
100%. Because
yeah.
I'm thinking in a scenario where, let's say you sell the property for a profit and you actually make money on it. But then as an investor, you actually lose money because the split happens before you pay off your equity. So you now have to pay off your equity or you have to pay back your initial investment from your split. And it's like, well, that doesn't make much
So
sense.
that would actually just be a mistake in the operating agreement, right?
Right.
That is
Yeah.
actually just an oversight, right? Because
Yeah. Yeah.
the equity is really only the equity above the total cost basis of the property, which the
Right.
capital partner's contribution of 80 or 100 grand is a part of the cost basis. So that's just an oversight in the operating agreement. To Chris's point, you need to be buttoned up. You guys really
Yeah.
need to flesh it out, have all the bullet points. It's
First
just
in,
as
first
simple as a
out.
checklist, right? So yeah,
This is
you're right. I
honest.
think it.
Yeah.
Go ahead.
No, I was
Yeah,
going to
go
say,
ahead.
this is honestly what initial consultations kind of look like, right? Because you're both sparking and you're kind of putting together the concept in your mind and articulating it with what the operating agreement actually says,
Yeah.
and we're kind of watching a consultation in real time right now. So it's a great
Exactly.
example.
Let's do a deal, David. Let's do it. I
Let's
want
do
to
it.
get to some
Let's
questions
go,
in the
man.
chat. I think we have two questions that are pretty similar. So let me ask them. Chris, we'll get your thoughts. I think the first one was Ari. How does that work with one partner bringing the property and the builder doing the build? Considerations if both are contributing or to obtain financing. Ari, if you're on the line, if you just want to flesh that out for Chris so he can answer it, and then I'll go to David Seuss's question as well.
Yeah, hey. Just general. Let's say I have a person who has bought a land lot and he wants to build on the home. I want to be the builder for it. He wants to provide the land. I want to provide the actual building part of it. We'll come together and then both of us combine to obtain like a construction loan. Or if I obtain the construction loan, of course, I'd be compensated for that risk. Or if he does that, how how would you determine? Because money isn't, we're really not coming out of pocket. We're coming out, him like a actual property value, and me, the construction part of it. How does that differ from what you mentioned already?
That would be more if you counted the debt that let's say he's got nothing to do with the debt. The
Hmm.
land guy's got nothing to do with the debt. Only you have anything to do with the debt.
Hmm.
So consider that as the same as you bringing cash, and then put a dollar value on the land, and also consider that cash, right?
Hmm.
And so that would be more of just a traditional, as if we were both funding. It's a bit of a different, you would almost get into saying like, well, I'm just going to make up a number, but let's say the total amount is 250,000. The
Mhm.
land is worth 100, and the construction loan, the capital that you're bringing via the loan is
Mhm.
150. You could
Mhm.
break that into percentage of ownerships just straight up, right? So you at the 150 are going to own more proportionately than the 100. And that's a different than what we've been talking about because you're both basically contributing capital, right? And you're going to get, and the easiest way to figure out percentages, and you can still get into like who controls it. You
Mhm.
can get into the managerial positions and all that, but
Mhm.
that's an easier one to just say like your percentage is X because you brought more money and his percentage is less. Versus where there's just one money guy and one catalyst that's not bringing any capital.
I want to offer some
Okay.
thoughts here too that I think will be helpful for Ari. So, what Chris is saying is that the person who brings the dirt, that brings the lot, they're contributing that lot, the cost basis of that lot, as a capital contribution. So that 250,000 for the sake of agreement would be the same as a capital contribution of cash, where that money needs to be returned first before the loan is paid off or before equity splits come into play. Or maybe you may decide that that capital contribution is paid after the first lien construction loan is paid off, right? You have to decide that up front. But just in general, you decide on the cost basis for the lot that's being contributed to the property as a capital contribution. So for the person bringing the lot, they may have bought that lot for 100,000, but the market value is 200,000. They
Mhm.
may want to bring that lot to the deal with a $200,000 cost basis because that is the value of the lot. Or they may
Mhm.
just bring it to the deal with a $100,000 cost basis, and you, as a good partner, get to enjoy the fact that they bought a good deal. But I think in general, when they bring that lot to the deal, they're bringing it as a cash capital partner. You, as the builder, if you're taking on the loan on your own, which typically you wouldn't because they want to own the deed to the lot, to the dirt. So you would
Mhm.
both be on the loan. In the
Mhm.
case that you are both on the loan, you are both absorbing the credit risk. If something goes awry, market goes sour, and they foreclose, you and the person that contributed the lot are both absorbing the credit risk because you're both on the loan. In the case where you work something out where they give you, for example, they bring the dirt and they give you a non-interest lien for the dirt. So I bought that dirt for 300,000. I'm going to put a lien on the property for 300,000 with no interest cost. And then you guys have a separate JV agreement with equity splits. That's just a different flavor, right? Where then you can go and get the loan on your own as Alejo Homes, and then there's no credit risk for the partner that brought the dirt. So what you're really deciding is the credit risk, is that worth a bigger equity split or a lesser equity split? Or do we just decide to have an even equity split? And I think what you mostly see is people just want to have good partners, people that can, do this repeatedly. And what they normally want to do is go into it in good spirits. So you're even going to see in that case where you're absorbing the credit risk and the other partner is not, they're just bringing the land with the dirt value. There's still a 50-50 equity split. And maybe you decide as a builder that you're going to take that management fee or that cost plus to compensate you for taking on the risk. To Chris's point earlier, there's 1,000 ways to chop it up. But I think, most importantly, that dirt's going to get paid back first. You can have it sit as a lien with non-interest, and then you can get the loan on your own and absorb the credit risk. But more commonly, the person that owns the dirt, they're not going to want to, lose that ownership interest in the dirt. So they'll want to be on the loan with you. So you're both
Mhm.
absorbing the credit risk. So you both have an equal split.
So
Okay.
to follow up on that, Chris, as the investor that owns the dirt, would it be advantageous to remain on title and not have your builder partner come on title? Or, and then second question, if they do come on title, do you do two joint LLCs? So for instance, me and Ari partner, my LLC and Ari's LLC would be on title, or do we form a new LLC? Because he's gonna have to build it under his builder's name. So that's kind of a little bit confusing. Could you flesh out some of that maybe?
Well, how do you want me to answer it? It's like, am I looking out for Mike first and foremost, or am I trying to, are we just all kumbaya? If I'm looking out for Mike, I'm saying, dude, stay on title, right? Like, because you're going to maintain a ton of control in the event that it goes bad. If that's off the table, then you'd say it's a great example of two LLCs on title. You could get into like a partition action type thing, right? And which has some advantages. But could be a little more difficult from an operating agreement standpoint. But the biggest thing is when there's lending, the lender is going to often tell you what they want to see, right? And they're going to say, and this is where you get into like people's credit worthiness and what all their, because a lot of times when you see somebody that's bringing their credit, it's because for some reason the land guy is not credit worthy, right? And so that happens all the time. So I think first and foremost, the lender is going to drive the ship, and they may say, "Hey, flip this into an LLC, a new LLC. You guys are both owners of the LLC, and you're now both personally guaranteeing it." My problem with that for you as the landholder, Mike, is that Ari just got put on title, and became an owner without funding it all yet. So if I'm behind the landowner, you as the attorney, I'm saying, man, that's got some risk to it, right? So it's like, I'll use another dating example, but you see this where like somebody just starts dating and then puts their girlfriend on title, right? Early on for no money. And now they now have a co-owner, right? But didn't get paid. And then they break up, right? And you can't unring that bell. They have an ownership interest. So my preference would be, if you're the land guy, is that you maintain title and we find some other way to, as the project goes, give Ari fair interest in the project, right? And you can do that in a number of different ways. You could have a separate agreement. You could give Ari lien rights, so that incrementally he can almost lien the property to ensure that he's going to get paid. Very much like a contractor or a bank would if you just hired them. Right? And so those are kind of, as soon as the biggest problem with the guy bringing the land with the guy that's borrowing money is that Ari's bringing his full contribution over time. But if you give him title, you've accelerated what he hasn't done yet and giving him the benefit of it today. If that makes
So
sense.
what Chris is referring to is like a ramp up, an equity ramp up. So at the different phases of the project, then that project manager, if you will, they get a bigger proportion of the equity. So normally the split would be 50-50, but we don't want to give that yet because they haven't done the work, to Chris's point. So maybe it is 20% equity upon inspection approval, right? And then 40% equity upon whatever the next milestone is, 60% upon the next milestone until the end, right? 100% of the 50% of the equity, 100%, right? At the point of final inspection, right? I think that is a very sophisticated way to do it. What I commonly see in the space is that we're more scrappy, we're more mom and pop, and we kind of just go right into it. We only really do deals with people that we feel like we know, like, and trust well. We know their character, their background, they have a track record. So we're probably more comfortable giving them 50% right up front because we're only doing the deal with them because we've seen them go through 5 other deals successfully, right? And they're part of a community like this where we get to know them, that kind of thing.
And one other thing is often in your example with the Mike and Ari guys is that we wouldn't do co-ownership at all, right? We would do some profit sharing agreement between your two companies or you two as humans, right? And we would say you would build it as a contract, as opposed to getting into ownership and operating agreements. It's like making it too complicated. I can get you guys to where you want to be by creating just a contractual agreement between you that most often gets into profit sharing, and so we can check all those boxes without having to be fully in bed together, right? As co-owners. So and you see that with GCs all the time where they're not owners at all. The GC has an interest and there's formulas cooked in to how the GC is going to get paid once the property sells, and way cleaner than all of a sudden now creating ownership where there wasn't any before. So I wouldn't say you have to take that LLC structure and jam it into every scenario, because in your scenario, I'd probably, between you and Ari, go the other way. I would avoid co-ownership and really more structure some form of GC type of an agreement. Which
And
the
then-
GC in Florida, the GC has lien rights. So, everybody can kind of be protected, just differently than these JV discussions.
Yeah, that's what I was going to say. I was going to say, so Ari gets protected in that he has lien rights up to a certain, number, and he's guaranteed first position or second position, so that's what I was thinking.
Yeah, I mean, the statutes in Florida give him tremendous lien rights. Even if we didn't have an agreement, if you had a handshake, his in Florida, he's got some great contractor rights. So totally kind of a lot of similar overlap conversations, like who's in control, how does this work, who has a say in how the property's sold, if but just slightly differently, because Mark, you never lost full ownership of the property. If anybody's ever been in a disagreement with a contractor, you're negotiating liens.
Right. Yeah. So David, I think you had a question in the chat that was very similar to Ari's, but I want to give you a chance to ask the question, maybe flesh it out some more if we didn't answer your question directly.
No, that's actually, he covered most of the stuff. I guess I didn't explain on mine, but in the case I'm doing a project which is going to be building to rent rather than building to sell, I guess my first logic in that case would be just create an LLC and have that LLC own the land and do an operation agreement, so we cover the whole addition of the land and how the property is going to be rent and so on, right? It will be a lot more simpler than having the whole liens and so on, because the exit strategy for that one in the long term or in the short term is going to be to rent.
The only clarifying questions I would have is then if you're using Mark's starting example of like Catalyst not bringing money with investor, you're in our examples, the property was liquidated and you're talking about splits. What you would get into in a rental situation is who gets paid in what order on the rent, right? So same fundamentals in terms of what are you talking about, as partners, but in this case, if I'm lending, my expectation better not be that I'm getting my money back, because that's not going to happen immediately with a rental situation. So you're just redefining the expectation of the investor with the catalyst.
Yep. Yeah. In my specific case, it's similar. You have one party owns the land, the other party is going to build it. You're going to have a loan to build it. And then once the property is built and rent, you're going to get a new loan to pay the building loan and to pay the land. And then you start from there, with your cash flow based on the rentals and the loan that you have in the property. So it's a lot more complex. It seems that the easy solution is just create an LLC, put the land in there with the two parties that are owners, and then put all the set of operation agreement, how you're going to get paid back as you go through the process.
Yeah, that's a great point. You see that in the buy and hold stuff. So you'll have the investor fund it with you, right? And then the project gets finished, rented, stabilized, and then traditional lending comes in refinances the property and cashes out the investor. And then whatever your upon percentages going forward, that's how you split the rent. But that
Okay.
you do see a lot where the investor can remain an owner and get the benefit of the long-term rent, but with the refinance can take their capital back out
Okay.
in some form or fashion.
So I think in that case, David, you want to be sure to show how much capital is going to be returned to the investor upon refinance, because
Mhm.
you're really at the mercy of the lender and their LTV guidelines, which if the market starts to falter, that it can go from 80% LTV to 70% in a heartbeat, right? So in that
Yep.
case, you'll have less access to capital upon refinance. So I think you want to spell out in the operating agreement that you're going to refinance to the max LTV allowable by the lender, and maybe you name the lender,
Mhm.
or prevailing LTV guidelines, whatever you want to say. And then you also spell out the equity split of the rental income, because it may be in the case where you have a pretty good property management business because you own your own rentals, but the other partner does not. So you may want to take 60% of the rental income, or 70%, whatever it may be, instead of splitting it 50-50, because they are pretty much a silent partner for the many years of ownership on that rental. So again, to Chris's point over and over, there's nothing wrong with being as buttoned up as possible for every possible angle
Mhm.
before you go into the transaction. But I think you'd want to spell out upon refinance, X, Y, and Z will happen, right? Upon stabilization, this is the equity split. That's important.
That's
And
awesome.
then also
Thank you.
make sure you also spell out capital contribution for CapEx over time. If an HVAC system breaks, right,
Yep.
who pays for that, right? So make sure you spell that out in your operating agreement too, because undoubtedly that's going to happen, as you know better than I, in a rental. There's going to be CapEx over time. Who pays that, right?
Perfect.
Your,
Thank you.
your example, David, is super common in the commercial space.
Yeah.
I was going to add, Mark, that before you even start this, before you put a contract together, before you even make an offer, you want to make sure you and your GC or your partner, your builder, are on the same page with like building cost at cost or cost plus a margin, right? Because I know Mark has run into this before where there was agreement, and then next thing you know, like, oh no, cost plus 30%. It's like, all right, well then, I just put the land up at a discount and you're supposed to build at a discount, or, so there has to be an agreement before you go buying anything. Make sure you really understand and talk about it in depth about it. So
We're
Well,
all friends until there's
that's
money
why a lot
involved,
of
right? And then
yeah.
numbers
Well, I mean,
change
that's
things.
like why a lot of times you have two agreements, right? So let's say that you were co-owners and take it one step further and say that you guys bought the land together. It was a new acquisition, and but then your partner's the GC. You still want a really tight construction agreement, right? So on top of the operating agreement, so you're going to have two agreements. And because you start peppering in a ton of construction terminology into an operating agreement, and it gets a little bit wonky, because his construction company is going to be different, right? And his construction company might not be the owner or member of the LLC, right? So now you're starting to get some confusion in ownership, confusion in duties. And so a lot of times you'll go, and honestly, if he's a construction company, you might not want his construction company to be a owner of the LLC, because his construction company gets sued all the time, like a lot of contractors do, right? So you want arm's length from that because you don't want any potential liability from his construction company, and so that's really where you start to, like, again, vet out how this all works together. But in your example, Mike, you almost always have two agreements: operating, construction.
While we're on this, I do want to open up for Q&A for the JV portion, and I just want Chris to briefly, we're keeping him past his time, so Chris, thank you. but also briefly touch on private lending because we have some in the group that will either want to lend themselves or think that it's more favorable to use a private lender instead of an equity partner. So I just want to briefly touch on that. I know it's a little more simplistic than JV agreements, but I'll throw it out to the group. Any scenarios that you're currently working on or that you may potentially work on, or questions that you have overall Q&A for Chris about joint venture agreements? Feel free to throw it out there. I think all the ones in the chat we've
I,
answered. It was Chelsea was following on David and David following on
yeah.
Ari. So
I've just got a point of clarification for Chris, just to make sure that
yeah,
I understand kind of what we talked about from the beginning. Um,
Sure.
uh, you're suggesting then that the best way, or one way in particular that we started off talking about forming the joint venture is to stand up an LLC and then have the operating agreement pretty much act as the JV itself, and the stipulations for the requirements, the expectations, the wartime effort, if you will, worst case scenario, that's all spelled out in the operating agreement. Um, so
Yeah,
the question,
one thing,
yeah, go ahead.
David, just for clarification, a JV would be much more like two companies coming onto title together, right?
Okay.
When you're starting up a new uh, entity, you're really just co-owners,
Mhm.
So you're using joint venture kind of loosely
Loosely.
because conceptually we all get it, right? We're working together and bringing different strengths and all that. But really, you're the most common is you're the catalyst, very, very, very common. You're the catalyst. You've got the capital coming in. You almost always give the capital a priority repayment, and
Mhm.
then most of your time is defining the split after repayment,
Mhm.
right? And so sometimes, like, where a private lender type guy would say, well, look, I also want some guarantee on top of it, right? And you're saying no, and so most of the negotiation, the structure is like foregone conclusion. LLC, different roles, we get into the managerial stuff, but if you're just talking about basic structure, brand new LLC with the capital repayment first, splits of the talking through the splits and how you define the splits, where you get management fees or no management fees, stuff like that.
Mhm.
And then the other is the control,
Mhm.
so how am I going to define control? And
Mhm.
that is really like over and over and over and over again.
Mhm.
So sometimes people come into our office with these like really complex things, and we drive them into something just a lot cleaner and simple. And
Mhm.
with the right operating agreement, that's just the cleanest way to go. We
Mhm.
say use a new entity as opposed to a lot of times people will have, well, I have this like old empty entity, and and a lot of times you don't want that because you don't know what liability is coming with the old entity, right? If
Mhm.
that old
Mhm.
entity had flipped a few properties already, you don't want like that entity now getting hit with a misrepresentation case,
Mhm.
right? Or something like that. And so you're just starting fresh. There's nothing to worry about.
Mhm.
If
Mhm.
you're the catalyst, I'm talking to you right now as the catalyst,
Mhm.
I'd say give the guy his money because if he's a lender, he's expecting that, or it's a non-starter,
Mhm.
and then get into the details from there.
So I guess let's say we're talking about a project, a new construction project. There's funding for the project. There's a GC for the project. The LLC is formed. Everything's stipulated in the operating agreement. Everything goes great, and we sell the property for a profit. We pay off the capital investment, and then everybody gets their split as it's stipulated. Bing bang boom, no issues. At that point, let's just say it's a one and done. Do you dissolve the LLC at that point, or do you, like potentially just go into another deal with that individual? Let's say like, oh, that was great. Let's do that again. Use the same one, or would it be great to dissolve it and start a new LLC with a new operating agreement? Like what? How does that work?
If you like the operating agreement and it worked, because let's say you have a construction defect, right? So like I wouldn't make any presumption that a new construction is any less liability than a rehab flip. You
Mhm.
know, so your operating agreements, perfectly fine. So you just rinse and repeat with a new
Mhm.
entity. So if something happened with the old entity, they're kind of suing a shell, right?
Mm.
Whereas if that old entity got sued and it has a current asset, now they've got something to chase off of an old project, and so just the the conservative advice from any real estate lawyer would be just start fresh. Use the same
Yeah,
operating
anytime. Yeah.
agreement, just start over.
So
And
same operating agreement, but new company,
yeah, new
right?
names. You
New
gotta make
name,
some
that's fine.
edits in the Word
Yeah,
document,
ABC one
but
two three, ABC 124. So, but can you dissolve the LLC once the project is completed, the house is sold, and payments are made?
yeah,
And then what happens then if, let's say there's an issue with the property, and the person who purchased it, like 5 months later, is like, oh, there's an issue, and I want to sue the builder, or I want to sue the company that I bought this from, but it doesn't exist anymore. How does that
yeah, it
work?
happens all the time, right? And that is its own form of asset protection.
Hmm.
It gets complicated, and then if they really want to pursue it, they've got to do what's called piercing the corporate veil to get to David as the human, and that's hard.
Okay.
So, and what we see in residential lawsuits is that it's a 20 or $30,000 issue. Well, you're going to spend 50 chasing it. So
Is it worth it?
those lines of defense kind of dissuade people from signing up that lawyer. It
Hmm.
also dissuades a contingency fee attorney from taking it, right? So if I'm billable
Hmm.
hour, I might still take it because you're willing to pay me.
Hmm.
If I'm contingency, like a personal injury attorney, I'm
Hmm.
looking at collectability.
Hmm.
And I'm looking at this being like, this is a
Hmm.
mess. Like, I'm out.
Hmm.
I'm not taking this case, right?
Hmm.
Which is a defense for you.
Hmm.
Um, whereas I looked at it and you're got this new project in the old LLC's name, and it's got a ton of equity in it, from what I can
Hmm.
tell. Like, I'm coming
Easy to
for it,
go after. Yeah.
and it incentivized me. I'm gonna chase it because
Hmm.
I think I'm gonna get paid.
Yeah. So in other words, it really does behoove you to stand up that new entity every time you have a new, and just keep rinse and repeat. Copy that operating agreement, change the name of the company, and just rinse and repeat.
We have clients that have been using the operating agreement, that we gave them a decade ago, and we do their closings, but I haven't heard a word about the operating
Yeah.
agreement. They've been using it
Yeah.
over and over for a decade because it
I
was
love it.
it was well done. And by well done, meaning they took the time to ferret
That.
out all these
Yeah.
war games.
Yeah.
You can have a really well drafted operating agreement, but it says the wrong things.
Sure. Sure. And then I guess the last question, and I'll give it back to the group. Um, is it most common when you're doing some sort of joint venture to have it in the operating agreement, or do you also very commonly see just an agreement between two parties on a piece of paper, that's like the operating agreement, but without the entity itself?
I would throw it right back to like Mike and Ari's example, where
Right,
that's
that's what I'm thinking of.
that's
Yeah.
not going to be ownership at all.
Sure. Yeah.
Ari's going to bring X, and in a certain way, Ari's kind of serving as the lender and the GC, right? Because
Hmm.
so there's a lot of times depending on the roles,
Hmm.
but but that's just a different scenario than you're the catalyst. I'll
Hmm.
tell you the best way that we watch catalysts go about it
Hmm.
is that they're seasoned, they know what they're doing, they already have the operating agreement, and it's not really a discussion. They're out raising capital and saying, like, here's my business model, this is the operating agreement, it's done, this is how I do things, and these are my traditional returns. So you see the process change with the guy that's been doing it successfully for 10 years versus the guy that's doing it for the first or second time, right? So the guy that's been doing it for 10 years, it's not really as negotiable because he's saying, this is a hell of a return. I'm excellent at what I do. This is the operating agreement by which I operate. You're either in or you're out, right? And usually they have a pool of investors that they go to. And what the seasoned guy is doing is shopping the best deal for him on the split, right? Which is basically which investor is willing to take the least return, right? And that's really the difference that we see. So like, I'm not having these hypothetical war games with the seasoned guy. He's done this too many times, like, and he's too good at it. And he's got a line of people that want to invest, right? So he's out really driving the ship, shopping the best deal for him. The one where we're getting into these conversations are usually either new to the game or it's a new relationship that they're trying to figure out, sometimes for the long term. But I do point that out because, you know, if you're really good and you're getting a good return, a lot of this stuff is not going to be debatable. Like, you don't have time to mess around with debating, you know, control and whether, like Keely was saying, paint colors and sales prices. Like, that's not how this works, man. You're investing, I'm going to get you a return.
Right. Yeah. And that's kind of what, and as I'm thinking of a situation as the catalyst, where I go out and I find private money, right? And that's not a lender. Like, it's just, you know, a friend or a family member or something like that wants to invest a bunch of money. They want to get a nice return. I want to invest next to nothing or a small amount compared to whatever they're investing. And then I go out and I source and I put this whole thing together. And then I've got an LLC and I've got funding. I want to get a return. I want to give them a return. And then I want to create a system where everybody makes money. And then we can do that again, over and over and over and over again. Right.
Yeah.
So as a catalyst that has, let's say, you know, I find $400,000 in investment and I put 100 grand in, you know, that's like an 80-20 split, right? Can we structure the operating agreement where this member, that's me, the catalyst, is the managing member, even though I have a minority share in the equity, and I can make the decisions, you know, with the contractors on the build process and stuff like that to, I guess, justify my return and stuff? Or is that common?
I mean, if you ever just Google like manager managed versus managing member, and so you've got members and then you have a manager. And so you most commonly see that as a manager managed. And then in the operating agreement, it has your menu of all the stuff that you're allowed to do as the manager, carte blanche.
Okay.
Right?
Okay.
And so what you're describing is more of a manager managed, which, because think about this, in a manager managed, you don't have to necessarily be the owner to be the manager, right? So you can be a non-owner and still be the manager. And, you know, so that if you ever just Googled it, you'd be Googling manager managed.
Yeah. Even though technically with 20% ownership, I am a member, right? But it's a minority member. So it'd be more akin to just somebody who doesn't have any equity at all that's managing the LLC, right?
Well,
so
it's more about
voting percentage, you know, your voting percentages. So you'd want to stay out of that because it wouldn't make any sense, right? You're never going to carry the day with a 20% interest, you know, and so
you'd have to stipulate in the operating agreement that the decision making comes down to delegation to the manager, not based off of ownership percentage. Correct.
There's a paragraph in the operating agreement that says like roles and authority of manager.
Sure.
That's where I use that power of attorney kind of thing, right? So a power of attorney gives you these rights over somebody else, you know, over a human. And
so if you guys go on school, in the classroom section of school, there's a resources tab. And in the resources tab, we have a sample joint venture agreement between a catalyst and a JV or a capital partner. And we have all of, inside of that agreement, all of these control monitoring issues that Chris has been talking about, they're all touched on in that agreement. So even if you don't use that agreement, Go ahead and pull it up when you get a chance on the school platform, and you can see all of those line items that show, okay, the catalyst, he has full decision right authority. Here's what happens in the event of a loss, right? All of that is in that agreement. And then, of course, after this call today, we're going to get the Boss Law operating agreement version on school as well.
I love it. I think we got all my questions answered. Thank you so much, Chris.
Yeah, no worries.
Anybody else questions about JV agreements? And Chris, if you have another 5 minutes or so, we'll just touch on lending. If not, we can table it and do a whole nother call on lending.
Yeah, I mean, let's just jump right to it, right? Lending is super clean. And if you're the lender, if you're the investor, the only reason you're rolling away from being a lender into being an owner is because you're going to make more than 18%, right? Because if you wanted just pure protection, it's having a first position with a ton of LTV, right? Like you're going to be okay. No matter what happens, you're going to be okay, right? You have an insurance policy. Just think about your home mortgage, right? So you've got all these protections cooked in where even if the house burned down, I'm okay. The insurance proceeds come to me, and if you don't get the insurance policy, it's default. If you don't pay the taxes, it's default. If you don't pay your contractor, it's default. So there's all of these protections in the lending, which for a catalyst makes it cleaner too, right? So you're not getting into a wonky operating agreement. So most of the time, if I'm talking to the catalyst, my question is always like, hey, can you just borrow the money? Because it's going to be a better return for you. It's a lot easier, like pay the guy and everything's cool pursuant to the loan, right? And you don't have a partner at all. That's always where we say, because, tell me the reasons, unless you can't get the lending, tell me the reasons why bringing in partners, and not to say that there's not good reasons, but tell me the reasons why you would do this over why you wouldn't lend versus bringing in co-owners where you're going to pay out more than you would. That's always where we start from, and then from there, you get into these combinations like where you have investors and lending, and you can spin a million different scenarios with that, but most of the time, and I just say it over and over, if you're the catalyst, the reason, particularly if you're dealing with your investor is used to lending, which a lot of them are, they are traditionally very versed in private lending. The reason why they're excited to get in with you as a co-owner is because they're going to be making more than 18%, which anything more than 18% as an interest rate in Florida is actually a crime, right? So that's really, take a step back and always think about that. It's just easier, cleaner, and if you're the lender, you foreclose, right? But also what's great is if you're the borrower, you have full control, your operating agreement, and you might still use an LLC, but your operating agreement just went from 40 pages to 2.
To give a few thoughts for the group. So typically what we see for private lending is, this is a dream scenario. If you can find a private lender, the advantages are just the ease of business. The fact that you don't have to overcome underwriting hurdles like, appraisals or, credit underwriting, right? So a lot of it when we're looking for private lenders is because that's going to get us quickly and easily into deals. It typically also is just going to fund an entire operating account for us where we can write checks to our contractors or subcontractors without having to go through the draw reimbursement process. So, private lending scenario is they give us the money to acquire the property, and then whatever the build or rehab cost is, that's put into an operating account, and we can use that at will to get through the project. So that's a cream puff scenario that allows us to quickly move through deals. I think a couple of things to think about is, so Chris is mentioning the 18% per annum interest rate. So the annualized 18% rate is the max that they can charge. I'm curious, Chris, if, let's, what about a flat rate of, let's say, 15%, and then the project gets done in 6 months? Does that trigger anything that we should consider? Is that kind of a gray
Yeah,
area because the deals
you
don't come
gotta
up? Or,
stay. If I'm representing the lender, you're like, man, that just sounds like a way around an interest rate, right?
yeah.
And
Okay.
so and there's a lot of consequences for a lender if they get tagged with violating usury. So you want to be very, very, very conservative with usury, and not to cross that line. And that's why you watch these lenders move into that equity role, because now it's not lending at all, and so all lending rules are out because it's not lending. Where we see most catalyst deals fall short is where the catalyst, especially young to the game catalyst, new to the game catalyst, just don't have the capital to bridge the LTV gap, right?
Mhm.
Whatever that might be in a construction type deal, or, and so really like the LTV, whatever the project is, it's almost always an LTV thing, and so
So you're
that's
saying the
where
catalyst is really looking for a lender to provide the gap funding, the difference between what the first lien lender will give them on the property, and what the total acquisition is, right? So basically down payment and things like that.
Yeah, let me spin it. Sorry, I'll explain it even more. So the catalyst has no money, right? But it's all 100% sweat equity. Found the property, was the bird dog, is the management, is the construction, like the whole kit and caboodle, just doesn't have the money. And so they have a lender, but the lender's not willing to fund 100% of the project. And so where we see the blend of lending, and Mark, this is your example from earlier, where you see the blend of lending with co-owners, is where the catalyst doesn't have the capital to bridge the gap on the LTV with the lender, right? And so now they're out procuring investment to bring in that capital so that the lender is now willing to lend. And that's where you see that more often in newer or smaller catalysts, and you see it less and less as the catalyst becomes more and more credit worthy, has their own capital, and then you're watching the catalyst almost always go to lending, within certain whatever their parameters are. They may go on a big project as co-owners and collaborate, but within their strike zone, they're almost always lenders, lending, exclusively with no partners over and over. And that, you guys can speak way more than that. That's just sort of the life evolution of a catalyst.
Yeah, once you become a proven operator, people will be they'll require less of a return because there's less risk involved, right? If I can almost lend to you in a guaranteed fashion and get a 15% annualized return, well, I'm happy to do that. It's when you're not a proven operator that I have to adjust my return and say, well, in order for me to take the risk, I don't want a 15% return. I need a 30, 40, 50% return. So there's always this risk adjusted return view perspective in any aspect of investing. And I think so, just to touch on something that you just said and kind of bridge the gap there. So typically, when we're going to achieve private lending, that's a first lien scenario. Project gets foreclosed on, first lien is paid off before anybody is paid a dime, right? Now, if we're using private lending as gap funding, well, the lender, hard money or otherwise, that is going to be the first lien. They're paid off in first position. Then your private lender is then second lien, which is less in the hierarchy, less favorable, and riskier for the private lender. So if you are private lending, consider that. You may want to adjust your return and go to the cap of that 18% if you're in second lien position, because you are taking on more risk. If something goes awry, the hard money lender is paid first, and then you're paid afterwards as a second lien, right? And then it's just something to think about. So to Chris's point, as you become an operator, somebody still may be willing to lend you in second lien fashion at a decent rate. 12, 13%, whatever it may be, because you're proven. But when you're not, you're going to have that risk adjusted interest rate applied to the deal.
Yeah, nailed it. That's exactly how it goes, and you're still better off usually doing the gap versus the ownership anyway, right? Even if you're paying usury rates. So, in that hierarchy, if you're the catalyst, what are my order of how I hope to get this deal done? It's always some forms of lending and then giving up equity.
Equity as a last resort. It's because you have to. I think what we see most commonly is people do it because it's easier to convince somebody to go into a deal if they're getting equity. One, because they feel like they're more involved, there is a bigger return, it's something to talk about in their social circles, or they're just a control freak. So typically we see a lot of people going into equity scenarios because it's just an easier sell on behalf of the catalyst. But I think to Chris's point, the more favorable position, more often than not, is to really just be the pure play borrower, first lien and second lien, because giving somebody 15% on that second lien, you're going to have more profit, take home profit, than if you were to give them 50% equity on the overall margin.
Yeah, you probably need some form of therapy if you said, no, Mark, I really like going back to like a pool of investors or co-owners and asking them what color I can paint the house. So right, there's probably need some help.
All right, we've kept you so long, Chris, and this has been awesome. Everybody's been texting me, the folks that left, like, I hated to leave. It was such a great call. So we're so grateful for you. Group, I'll open up 2 minutes. Any private lending questions, and then we will let Mr. Boss get back to his day. Any questions, private lending, or something that we missed? Ask for now, forever hold your peace. All right, cool. Chris, this has been amazing. Of course, we hope this is not the last time we get to see you. You're a sponsor, so we're just going to force you to come around. But we're so grateful for you. This is awesome.
Just tell me when you're tired of hearing my voice,
Thank you, Chris. Thank you so much.
Thank you, Chris.
Thank you, guys.
Thank
It's always
you.
a
Thank you,
pleasure.
Chris.
Thank you all. It's good to see everybody.
Have a
You
good
guys
day.
are
Thank you,
awesome.
Chris.
See you soon. Have a great day,
Good
all.
job.
Thanks.
Bye, guys.